Hello, my name is Corey Bács, and I'll be reviewing case number 17-003. The student at the center of the case is a rising sixth grader that has profound disabilities attributed to being born prematurely and weighing 2 pounds, 13 ounces at birth. At birth, the student required a tracheotomy and eventually needed constructive surgery to repair the airway and close the trach. She remained hospitalized and developed several staph infections and other health concerns. The student was initially found eligible in 2005 for special education services at 2 years of age under the designation of developmentally delayed. In 2009, her eligibility changed to orthopedically impaired. And in 2012, her eligibility designation changed again to other health impairment and orthopedically impaired. This remained her designation. Her documented disabilities included right hemiaplasia, cerebral palsy, neurodevelopmental disorders, visual tracking problems, language disorder, inattentive type of attention deficit hyperactivity disorder, developmental coordination disorder, learning disorder, deficits in higher order reading comprehension, voice production disorder or dysphonia, deficits in written expression, deficits in arithmetic calculation, generalized anxiety disorder, obsessive compulsive disorder, brain injury. As a result of some of the items the student used the following assistive devices to help her with daily activities. She used a walk aid as a functional electrical stimulation, chipmunk shoe inserts, Uniflex night brace, and eyeglasses. She was also prescribed Prozac for anxiety and OCD, plus Focalin for ADHD. Her parents are described as loving and very active in their child's education. They actively participate in all IEP meetings. The student started school at 2.5 years old in the developmentally delayed preschool program at the public school where she remained for 2 years. Due to the father's deployment in the military, the family moved to Rhode Island where the student attended school for an additional 2 years. The family moved back to Virginia and the student attended her original school for her pre-K, kindergarten, and first and second grades. The family later relocated to a different county in Virginia for the student's 3rd and 4th grade years. In 2014, the family returned to the county in Virginia where she was enrolled into the 5th grade. The IEP developed by the previous school followed the student to the new public school and served as a stay put until the public school could develop its own IEP. Several modifications were made to the stay put, and the student continued her educational experience in hopes that a more suitable IEP would be developed. However, despite 16 IEP meetings, the stay put IEP remained in place and no other IEP could be agreed upon. Initially, the parents were asking for a one-on-one aid for the student and asked for this request numerous times over the 16 IEP meetings. The public school did not agree to provide the aid, continuing that the student did not need one. The parents requested evaluations to help the development of the transfer IEP. Initially, the public school disputed the request as being unnecessary. However, they eventually agreed to conduct them as a means of compromise to the parents. By March of 2015, the student was tested by a pediatrician and a developmental pediatrician, both who wrote letters identifying the student with issues in language processing, memory, vision, fine and gross motor skills. Both doctors agreed that the student needed a one-to-one aid. The parents renewed the request of the individualized assistance in an IEP meeting on March 30th, 2015. The public school once again denied the request. The parents alleged that the student's teacher had not been implementing many of the stay put IEP provisions. Another concern was that the teacher was placed on a performance plan of improvement and later removed from her teaching position. The parents alleged that serious harm was caused by this teacher to the student. They claimed that the teacher's failure to implement the modified stay put IEP resulted in a lack of free appropriate public education, or FAPE, that left their child struggling academically and socially. On May 17th, 2015, the parents presented a detailed statement of disagreement to the public school. The statement included numerous issues that included the one-on-one aid, the elimination of goals, and a failure to include agreed upon modifications to the IEP. When the student received her final grades for the 5th grade, she passed and was promoted to the 6th grade. However, she had failed all of her standard of learning tests, and her parents believed she was regressing socially and academically, and that her promotion to middle school was a social promotion. In July of 2015, at the parents' request, the student was evaluated by a private school academy. A recommendation for the student to repeat 5th grade because she lacked academic and social skills to meet success at the 6th grade level. On August 3rd, at a special education committee meeting, the parents asked the public school to conduct additional testing in the areas of occupational therapy and physical theory, but not speech and language. The public school agreed to conduct an individual education evaluation, social cultural update, and teacher observation, but not the assessments that the parents requested. On August 10th, 2015, the parent gave the public school notice of their intent to unilaterally unenroll the student at the public's expense for the school year 15-16. On August 25th, an IEP meeting was held that placed the student in a public day school against this parent's request. In a total, 16 IEP team meetings were conducted with no resolution. No agreement could be reached between the parents and the other IEP team members that produced an IEP that could be all agreed upon. Therefore, the student's IEP remained in a modified stay put IEP that the student transferred in with and the previous school division after her 3rd grade year. On July 11, 2016, the parents signed a revised IEP disagreement and through counsel filed a due process complaint. A due process hearing initiated on July 11, 2016. The issues of this case are identified as the following: whether or not the local education agency, LEA, had properly implemented an individual education program for the student, whether or not the LEA was providing the student with a free appropriate education, FAPE, whether or not the LEA provided sufficient educational evaluations to formulate an appropriate IEP within a reasonable time, or whether or not private day placement is required for the student to receive FAPE. For the first issue of whether the LEA properly implemented an individual education plan for the student, the hearing officer noted that IEPs are a necessary component of FAPE. In this case, the student's unique and complex needs as a disabled child with varying degrees of complexity and required interventions and accommodations were neglected by the public school. Additionally, the public school accepted the transfer IEP for implementation. The acceptance document clearly states the IEP placement could be transferred and implemented by the public school. The parents testified that the accommodations listed on the IEP had not consistently or even been implemented. The parents also included recordings where teachers admitted to this fact. The hearing officer found the parents to be credible, and the failure to provide IEP accommodations very troubling and presented procedural violations. The test results conducted showed that the student had academic regression. Of concern was that her teacher was on a performance improvement plan and subsequently removed from her position. The parents paid for the student to receive private academic tutoring and social skills support. The hearing officer found that the public school failed to provide the student with FAPE due to the lack of the stay put protections by failing to implement crucial components of the student's IEP. Due to the lack of accommodations that the student was accustomed to at her previous school, the parents found that the hearing officer found the public school hindered her educational transition. For issue 2, the hearing officer emphasized that IDEA was enacted to ensure all children with disabilities have availability to them a FAPE that emphasizes special education and related services to meet their unique needs. She states that in this case, the students' needs are unique and extensive. The parents testified that they did not believe their concerns were taken seriously and that they lost confidence and trust in the public school. The hearing officer cites the Board of Education of the Hendrick-Hudson School District versus Rowley that emphasizes that instruction and service must be provided at the public's expense, must meet state educational standards, and comport with the student's IEP. She contends the stay put IEP was not followed by the public school, and the parents are not obligated to sign a proposed IEP to which they disagree. She rejects the public school's finding that the student received sufficient educational benefit and found regression although the student passed the 5th grade in public school. She finds that the parents meet the burden for this issue and that the student was denied the educational benefits to which she was entitled pursuant to IDEA. She also finds that the student was provided only minimum educational benefit by virtue of the accommodations she received and was therefore denied a FAPE. For issue 3, the hearing officer found that the parents did not meet the burden and requested relief be denied. She found that the public school did not act unreasonably and acted quickly to complete testing to the agreed upon assessments. She notes that the public school is not obligated to automatically or agree with every one of the parents' requests for additional testing. She also found that the public school provided sufficient educational evaluations to formulate an appropriate IEP within a reasonable time. The parents will not be reimbursed for independent evaluations or tutoring or social skills training. Lastly, the issue of concern is the students being educated in her least restrictive environment. IDEA does not mandate that every child with a disability be placed in a regular classroom, regardless of individual abilities and needs. The general rule in placement is that each disabled child's placement must be individually determined based on that individual child's abilities and needs. In determining if a placement is appropriate under IDEA, the following factors are relevant: the educational benefits available to the disabled student in a traditional classroom, supplemented with appropriate aids and services in comparison to the educational benefit to the disabled student from a special education classroom. The next bullet, the non-academic benefits to the disabled student from interacting with non-disabled peers, and the degree of disruption of the education of other students, resulting in the inability to meet unique needs of the disabled students. The hearing officer cites the court case of Hartman versus Loudoun County Board of Education, holding that more restrictive environment provides a student with FAPE. The child should be placed in a more restrictive environment. The student thrived in the private school academy setting, and that the smaller environment, specialized instruction, and individualized programming helped her to learn and focus. The hearing officer found that the academy can offer the student FAPE, and she was not convinced that was something the middle school could do. She finds that the student will receive educational benefit from continued attendance at the private school academy. She commands that once the student finished the 16-17 school year, the parents and the IEP team should meet to discuss the social and emotional readiness and maturity to return to the public day school. Finally, she found that the student would attend the academy for the 16-17 school year and that the parents met their burden. Hearing Officer Mitchell concludes the findings that the public school failed to provide FAPE in a timely manner prior to the unilateral placement at the academy. She finds the public school responsible for the student's enrollment cost onto the academy for the school year of 15-16, and the student should be educated at the public's expense for the 16-17 school year. Noticeable strengths of the public school include making multiple attempts to create the IEP, 16 IEP meetings at all and 1 SEC meeting before the due process complaint was made. The LEA also conducted numerous assessments under the parent's request that may or may not have been needed to create an agreed upon IEP. Noticeable weaknesses of the division are numerous. Failing to provide a free appropriate public school education is apparent. The parents requested a one-on-one aid to ensure the student would continue to meet academic and social milestones. Because of the stay put IEP was not modified to the student's present level of performance, the student was unable to grow and actually regressed. While the teacher was removed from the school setting, ultimately the administration is to blame for not implementing timelines and support measures to ensure the student's success. Lessons learned in this case: transfer IEPs should be thoroughly examined before accepted to ensure the LRE placement is appropriate and will allow the student FAPE. Timelines should be kept in accordance with IDEA. Timelines are in place to ensure students do not experience delays and lapses in accommodations that are needed to support specially designed instruction. Recommendations from assessments for services and accommodations were not put into place. These recommendations, such as small group instruction, are recommended for differentiation of content to meet the student's needs. Thank you for listening.